In this lesson, we're going to talk about contracts, specifically the Statute of Frauds and the essential elements of a contract. So what is a contract? Basically, a contract is a promise or a set of promises. And by definition, it is a legally enforceable agreement to do or not to do certain things. So in real estate, we have contracts like purchase contracts, listing agreements, leases, options, and many more that we'll talk about. So way back when, in merry old England, King Charles was having some difficulties trying to resolve disputes between his subjects. And he came to the conclusion that certain agreements were so important that unless they were reduced to writing, they would not be enforced. And this became known as the Statute of Frauds. And today, here in the United States, every state has a statute of frauds. They differ from state to state. But in essence, what the Statute of Frauds states, and what you want to remember for the examination, is that the Statute of Frauds requires certain contracts to be in writing in order to be enforceable. What does that mean? They would have to be in writing in order for you to be able to go to court and force the other party to live up to their end of the agreement. So here in Arizona, there are 4 aspects of the Statute of Frauds that apply to us in real estate. Oh yeah, better get everything in writing, otherwise you'll end up living in a cave on a blinkety-blink mountain. Very important to keep in mind, as a real estate agent, you always want to put things in writing. So what does the Statute of Frauds require? The first is employment agreements. And by definition, we're not just talking about any old employment agreement, we're talking about real estate employment agreements. The statute in essence says that any agreement hiring a broker to help buy or sell a property needs to be in writing to be enforceable. What does that mean? It means listing agreements and buyer-broker agreements are required to be in writing because of the Statute of Frauds. Secondly, any agreement which purports to transfer an interest in real property. So that would include simply purchase agreements, options, deeds, etc. Third one is a lease for more than 1 year. So since the Statute of Frauds says that a lease for more than 1 year has to be in writing, that implies that a lease for 1 year or less would not have to be in writing. And technically that's true. But as a real estate agent, if you are assisting somebody, let's say you're in property management, and the parties enter into a lease agreement, then you better make sure that that agreement is in writing, even if it's a month-to-month or exactly 1 year. But what does the Statute of Frauds say? It says that leases for more than 1 year must be in writing to be enforceable. And finally, the Statute of Frauds states that any contract which spans more than 1 year in time must be in writing in order to be enforceable. So let me recap here. What I want you to remember is that the Statute of Frauds requires certain contracts to be in writing in order to be enforceable. Now, the next thing on our hit parade is the essential elements of a contract. So let's say that you, as a real estate agent, helped a buyer and seller put together a purchase agreement. And the next morning, after having nightmares about buying the property, the buyer wanted to get out. Well, what the buyer would probably do is go to his or her attorney, and their attorney would look over the contract, looking to see if there were any essential elements missing from that contract. So let's take a look at the essential elements in a contract. The first is, are the parties competent? So you have to have competent parties in order that a contract be enforceable and valid. So obviously, minors, people who are under the age of majority, and in Arizona and most states that's 18, are not competent. Also, someone under the influence of drugs or alcohol at the time they entered into the contract would not be considered or might not be considered to be competent. And if they acted very shortly after waking up from their drunken stupor, let's say, then they possibly would be able to overturn that contract. Another issue that's becoming more important and more common today is older people who might have Alzheimer's or dementia. So if you as a real estate agent were to suspect in any way, shape, or form that one of your clients might not be acting rationally, then it's something that you'd want to talk to your broker about. Because certainly if a person was held to be incompetent by a court because of dementia or Alzheimer's, then they would be able to overturn that agreement. So number one essential element, the parties must be competent. Second essential element is consideration. In other words, there must be something of value given and taken in the transaction. And most commonly, of course, that's money. But it could also be goods and services. In other words, I might offer you a free real estate course, or I might offer you some carpentry work if I was a carpenter, or dental work if I was a dentist. And that is considered to be a valid form of consideration. Also, in the case of a gift, love and affection. That's why those hearts are there. Love and affection, in particular, of course, between relatives, is a valid form of consideration. So, competent parties and consideration, the first two essential elements of a contract. So, that buyer's attorney would be looking at the contract. The attorney might ask the buyer, are you competent? Well, obviously, if they're over 18, the fact that they are of age will not allow them to back out of the contract. Secondly, were they under the influence at the time they signed and entered into the contract? The answer is probably no. Third, did they offer some consideration? Was a price stated and probably some earnest money given? And the answer there is probably yes. So far, that buyer's not going to be able to back out of that contract. The third essential element is that there must be a meeting of the minds. In other words, there has to be an offer and a complete acceptance of that offer. Oftentimes there is a negotiation going on where there's an offer, a counter to the counter offer, and so on. But finally, the parties wind up totally agreeing on all terms and conditions. That constitutes a meeting of the minds. So in reviewing that agreement, the attorney for that buyer trying to get out of the contract would look to see if there were any things missing relative to the meeting of the minds. The fourth essential element is a legal objective, also called a legal purpose. In other words, the purpose or objective of the contract must be legal. So for example, if you and I were to enter into an agreement where we agreed to defraud a third party out of their life savings, and then you backed out just before we went ahead and did that, then I would not be able to enforce that contract against you because of the fact the purpose of our contract was illegal in nature. So the fourth essential element is that there must be a legal purpose or a legal objective. And certainly the objective of a purchase contract is to buy and sell a property. So that contract, of course, has a legal objective, a legal purpose. Now, those first four, competent parties, consideration, a meeting of the minds, and a lawful purpose, are essential to all contracts. Most real estate contracts are required to be in writing in order to be enforceable according to the Statute of Frauds. But as we mentioned a few minutes ago, leases for 1 year or less technically are enforceable even though they may not be in writing. And the sixth essential element of a real estate contract is a proper description of the property. The property must be described sufficiently so that, in essence, a surveyor or other person familiar with legal descriptions could ascertain the boundaries of the property from the description given. So this is not essential to all contracts, but it is essential to real estate contracts. So let's recap. What are the 6 essential elements? The first 4, which are essential to all contracts: competent parties, consideration, a meeting of the minds, and a lawful purpose. And then, based on the Statute of Frauds, for most real estate contracts, number 5 is to be in writing, and number 6 is a proper description of the property. So that's our discussion on the Statute of Frauds and the essential elements of a contract.